Please be seated. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12CR1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Mr. Brockler, how in-depth are you intending to get into the area that we spoke about at the bench right before the test, and specifically the MMPI-2?
Your Honor, my intention was to do as I had been doing right before we approached, which was to get into some of the general subject matter areas that the MMPI-2 gets into, and then to ask the witness, frankly, if he had reviewed the specific answers to those questions, and then compared them between the first test, the second test, or either of the tests, and any other statements he'd made to either himself or to any other mental health professional.
Okay. All right, Mr. King.
Judge, and that's the problem, Judge, and that's why I keep objecting to beyond the scope. This expert witness, the testimony of this expert witness is limited. That didn't mean that that's the only work that he did on this case for us. Now, he did review the data on the MMPI and the data on the PAI, and he has consulted with us about that, and he has indicated to us whether he thought that what the results were. I don't know if he's looked at the individual questions or not, or just the scales, but you know, he had other roles in the case other than testifying about the neuropsychological evaluation, in terms of being an advisor to us, in terms of giving us input on various things. I specifically did not go into those areas because they're not relevant to the work that he did and the information that he's imparting to this jury. So I deliberately did not do that. He didn't administer the PAI, he didn't administer the MMPI, he wasn't asked to, and he's not been asked to offer any opinions about those issues. And now we're getting into the particulars of those tests with somebody who has not testified about them, did not perform the test, and we're well beyond the scope of the direct examination, Judge, and it's just irrelevant to the issues that he has testified to before this jury.
All right. I went back and looked at the notes during the break, and Mr. King is right that he didn't go into detail or in depth into this area, but there were a couple of questions related to the MMPI-2. One of the questions had to do with whether Dr. Hanlon is qualified to perform the MMPI-2, and he said he was. And there was a slide which was apparently prepared by Dr. Hanlon that was put up in front of the jury that has the result of the MMPI-2 test that was administered by Dr. Gray. And although he was not asked any specific questions about the test results for that particular test, he was asked questions about the combined scores of the MMPI-2, the PAI, and the SIRS, and pointed out that there were 40 scales and that they indicated that the defendant was not malingering. And for the record, these are validity tests, and there are two categories. There's a category of testing, of validity testing, that is related to the neuropsychological test that Dr. Hanlon has been talking about for the most part. There's another category of validity test that includes the MMPI-2, the PAI, and the SIRS, and that's related more to psychological types of conditions or mental illnesses, and whether there's malingering related to that. And that's what we're talking about here. It's the latter category. And the graph or the slide that was put up during his direct examination showed the jury that the score on the MMPI-2 was 8 out of 8. It showed the jury that there are 8 validity scales in the MMPI-2, and that in August of 2013, the defendant scored an 8, and that in July of 2014, the defendant scored an 8. and that both of those tests were done through Dr. Gray. All of that came out on direct examination. And then at some point at the end of the direct examination, Mr. King asked a question about Dr. Hanlon's opinion. And the way he answered the question was to say something along the lines of, based on the testing that I administered and based on everything, on the testing done by Dr. Gray, my conclusion is, and then he gave the conclusion in terms of malingering. And he didn't specify it or limit it, to the SIRS. He said, based on the testing I did and based on the testing done by Dr. Gray, here's my conclusion. This is part of his materials. It's one of the slides that he prepared and presumably that he has relied on. So I think it's fair if you open that door for the prosecution to ask questions. So Mr. Brockler is not intending to go too much in depth, but I think what he indicated in terms of the questions that he's intending to ask, I think that type of questioning is appropriate given the direct examination. So the objection is overruled.
Is my understanding correctly that Mr. Brockler is limited in scope then to dealing with the issues of malingering that were in the MMPI, as those were the only scales that were shown? That was the only issue about the MMPI that this doctor testified about, or that there was any evidence about at all, was malingering scales. We're not going to be getting into all of the other scales. My understanding of the question that counsel asked was, what are the various domains of the MMPI, which includes psychoticism and all kinds of other things. There are 40 scales, some odd scales, and so, you know, what the court is saying is that I showed an exhibit that had the scores from the validity profile, and so I'm assuming that the court is limiting to Mr. Brockler to discussion of the MMPI with regard to that domain.
I'm allowing Mr. Brockler to inquire into the areas that he mentioned a moment ago when I asked him how in depth he's looking to go into this area. I think given the direct examination, I think the door has been open to those areas that he talked about. If he asks a question beyond that you want to object to, then you can object.
Okay, so hallucinations are out of the question then?
The areas that he mentioned is what I'm allowing. So if there is something beyond that you think is beyond that, you should object, and then I'll rule on the objection. All right? Anything else, Mr. Brockler, at this time before I bring the jury in?
Just to clarify that, because I think my last question was about hallucinations, and then I clarified audio and visual, and then I may have asked one more thing, and then Mr. King approached. I just want to make sure I don't do anything different than what I told the court.
I was referring to the comment you made after the break when I asked you how in depth are you intending to go into, and you mentioned the things that you mentioned. Those are appropriate. Those go to what makes up the test in general, what type of test it is, whether there was any information, whether he reviewed the answers provided by the defendant to that test or to those tests, because apparently it was administered twice, whether he compared the answers in the test to other information or other materials. I think all those things go to the test results that have been shown to the jury. I think it's fair game. The jury has been shown and told the information that I mentioned, and I think it's fair then to have opposing counsel inquire into the areas that were mentioned a moment ago after the break by Mr. Brockler. If there's something beyond that, then there can be an objection, and I'll rule on the objection.
Well, I'm sorry, Your Honor, but I'm confused, because the court just said that I opened the door with regard to the issue of malingering. And so now we're going to get into what are the various domains of the test. Did you examine the data for the whole test? Is there inconsistencies between the results of the test and other information in the record? I mean,
I don't think I said that you opened the door to the issue of malingering. I think you may have said that. What I said is you opened the door to the issue of the test results. You showed the jury the test results were 8 out of 8 in August and 8 out of 8 in July of the following year. He's entitled now to go into what the test is made of, what kinds of questions and categories are in the test, and to challenge the reliability of the score. He showed a perfect score, and he said there was 40 scales out of 40 scales in the MMPI-2, the PAI, and the SIRS. I think opposing counsel then is entitled to question that and to question the information provided in response to those tests. In other words, the significance of the scores. What do these scores mean? I think he's entitled to ask questions along those lines. You can't show the jury the test scores and then prevent opposing counsel from going into the significance of the test score, or perhaps things that may call into question the reliability of the test scores. This witness included this information in his materials, apparently relied on it, among other things, in forming his opinions. And he included it specifically in the slide that was put up on the screen that was shown to the jury during direct examination. I think opposing counsel now is entitled to ask questions about that and what he knows about that. And I don't know what he's going to say. Maybe he's going to say he didn't read the answers and he doesn't know anything about that. Mr. Brockler said at the bench that that's what he anticipates. And maybe that's as far as it goes. But I think he's entitled to do that. He included it in the materials, his materials that he relied on. And I think opposing counsel is entitled to inquire into those materials.
So I persist in my objection.
I understand.
That we shouldn't be going beyond the things I actually showed and talked about, because anything beyond that is beyond the scope. And for the record, I would anticipate that his answer would be, I'm relying on the report and the expertise of Dr. Gray. I didn't do these tests. I didn't analyze these tests. Dr. Gray did. This is what Dr. Gray said.
All right, so be it. The record has been made and I have ruled. Let's bring the jury in, please. Thank you.
But you have to ask. You have to object.
Please be seated, everyone. Welcome back, members of the jury. Mr. Brockler, I think you were about to finish your cross-examination. Dr. Hanlon, I remind you that you're still under oath, okay? Yes. All right, thank you. You may proceed.
Thank you, Your Honor. Doctor, we were starting to talk about the kinds of questions in general that get asked in the MMPI 2. You remember that?
Yes.
Let me back up a little bit and lay a little more groundwork for that with you. And that is, one, you are super familiar with this test, correct?
I'm very familiar with the test, yes.
Administered this thing 1,000 times? Less?
I've certainly administered the MMPI to several hundred times.
Several hundred times. Chose not to do it in this case, correct?
True.
Left that for whoever would come after you, fair?
Yes.
But for your January 15th, 2015 report and opinions, you indicate under records reviewed 2 reports authored by Dr. Thomas Gray from the Colorado Mental Health Institute at Pueblo, fair?
Yes.
And his reports make specific and detailed reference to the defendant's performance on the MMPI-2 and the PAI, correct?
Yes.
So where we were was talking about that this test, with these validity questions and scales that you've talked about to the jury, has 527 questions, fair?
It actually has 567 questions.
And
567 questions.
I've even said that number before and I screwed up. Thank you, 567. And those areas that we already talked about included hallucinations, both visual and...
Your Honor, beyond the scope.
Overruled.
Included hallucinations, both visual and audio. You've already talked about that. But there's other areas it gets... Is that true, by the way? Because you shook your head. I don't want to misstate something.
I'm not sure. When did I talk about that?
I thought right before the break, but that could have all been in my head.
I don't think so.
Okay.
I don't think I did.
The general questions that are asked in the MMPI-2, do they include questions asking about whether someone is experiencing things like visual hallucinations?
Yes.
And audio hallucinations?
Yes.
And other potentially psychiatrically significant things, correct?
Yes.
Including things about whether they feel that they've conducted themselves in a certain way here, there, or everywhere. Fair? The way their interactions with people is what I'm getting at.
Yes.
Commenting on their physical health and specific conditions. Fair?
Yes.
And a bunch of other things, right?
Yes.
Okay. Those questions are asked in a specific order, aren't they?
Yes.
That order never changes, correct?
True.
So the test that the defendant took in July of 2014 was identical in terms of the questions, the true-false questions that were asked of him when he took it in August of 2013, correct?
It should have been.
All right. Now, you did not go through the individual true-false answers to those questions we've described. Is that fair?
I did not.
And in not doing that, what you don't have the ability to do is to see whether or not his answers to those questions are inconsistent with statements that he gave you about similar topics. Fair?
Objection, relevance, beyond the scope.
Overruled.
Go ahead, sir.
Yes, given that I have not reviewed his answers to specific questions, I cannot relate them to specific answers to questions that I asked.
And you can't see whether or not those questions are inconsistent with any of the other many statements that you've seen in the reports that you considered for formulating your opinion.
Objection, relevance, beyond the scope.
Overruled.
Go ahead, sir.
True.
In fact, you can't even tell us whether or not his individual answers from August of 2013 are inconsistent with any areas or questions from the July 2014 test, correct?
Objection, relevance, beyond the scope.
Overruled.
I cannot.
And there isn't some, I mean, when we talk about these validity malingering scales, they're largely internal with the test, correct?
They are.
So one thing his performance on the passing, using a term I think you used, the malingering validity scales on MMPI-2 from August of 2013 and July of 2014, that doesn't even tell us if the statements that he agreed to or disagreed with, true, false, are consistent with any of the things we just talked about, right?
Objection, asked and answered, beyond the scope, irrelevant.
Overruled.
Go ahead, sir. Is that true?
No, the validity scales simply tell us that he produced valid profiles on both of those occasions.
Now, one of the things that we did during the break, and I appreciate you doing this, was we pulled out those sheets that we were talking about for that, the PRI 3 subtest. Do you remember that?
Yes.
We talked about the two that were impacted by time. Isn't that right?
Yes.
We looked at actually the defendant's performance on the two block design tests, correct?
Right.
And we looked at his actual performance as you graded it on the visual puzzles part. Is that correct?
Yes.
And those were the two that made up the biggest difference in the PRI, correct?
That's right.
And that big change is what made the biggest change in the overall full-scale IQ, correct?
Yes.
All right, and when we looked at them, what we discovered was this. For the visual puzzles, he missed more. He got them all within the time he was supposed to, correct? No time issues, right?
Yes, except one item.
Except one item. And did you tell me that when we were up there looking? I thought you'd said none.
I think at first I said no, and then I said
Okay.
yes, one item.
Thank you. But really what the decrease was because out of these 26 or 27?
26 items.
26 items, even though he got them within the time with the exception of that one, he missed like 5 puzzles. Is that fair?
That's correct.
On the other one, the block design one, he got them 100% accurate, didn't he?
Yes.
Just like he did in April of 2013, right?
Yes.
The difference is on 2 puzzles out of 14, on 2, he was slower than he had been before, correct?
On two, he was significantly slower. On one, he was a little bit slower.
But not enough to make the huge point difference on the, going off of that scoring thing you showed me.
It was a point difference. On the other two, he lost 3 points each.
So those two tests make up the bulk of the difference in his score. And those two tests, forgive me. Those two puzzles make up the bulk of the difference in his score off of the block design test.
Yes.
And he never went overtime on any of those puzzles, regardless of how complex they became, correct?
True.
And so he always got points for every one of the puzzles, no matter when he took the tests, right?
True.
So that full-scale IQ, it would be accurate to say that that thing shows this statistically significant drop in large part because of the way he answered 5 separate, 2 blocks, 5 puzzles, 5 separate, I'm going to say questions. I know it's not a question, but do you know what I'm saying? 5 separate items. Fair? I'm sorry, 7 separate items.
Yes, and yeah, that is to a large part. He did also lose points from the other two, from the working memory index and the processing speed index, not the magnitude of loss that he lost from the perceptual reasoning index, but there were, I just don't want the court to understand that it was exclusively related to those two subtests. There were other subtests.
And that's why I've tried to make my questions about the bulk of or the biggest part of, because I get there's other things going on with the many tests that you've put up there, some higher, some lower. I get all that.
Okay.
But at the end of the day, the biggest mover in terms of decrease in full-scale IQ is because of the way he answered 7 tasks on these 2 tests 20 months after he did them before. Is that fair?
That is fair.
2 weeks before trial.
Correct.
After 900 days in isolation. Fair?
I believe so.
Sorry,
I believe so.
$8.99. Thank you. I do want to talk to you, though, about one other test that was put up there, and you talked a little bit about it, and that was the Wisconsin card sorting test. He improved on that quite a bit despite those 20 months and those 899 days, correct?
He improved. I gave it to him the first time in April 13.
Yes, sir.
Then Dr. Manguso administered it to him then again in August of 14.
Yep.
There he made significant improvement.
Right.
Then when he came back and saw me again, he scored about the same when he saw me as he did when he saw Dr. Manguso.
Got it. Thank you. And still a big jump from that first time.
From the first time, yes.
And that's that Wisconsin sorting test that is a huge indicator of executive function, correct?
Correct.
Did you do that IGT thing again with him the second time?
I don't believe so, but let me just check. I did not.
So the only test we have of his ability really, well, not the only test, but one of the primary tests to help us know whether or not intellectually he can anticipate consequences in that cost-benefit analysis was the one you did back in April 2013. Is that fair?
That's the only test that is of that specific paradigm of cost-benefit analysis, yes.
And again, he did well on that one.
He did.
Finally, Doctor, you would agree, as you sat here yesterday with Dr. Manguso, that whatever testing you reviewed, whatever testing you performed, there's no indication to you that the defendant lacks the intellectual ability to form the capacity to know right from wrong based on societal standards of morality, correct?
That's true.
And there's nothing else, same question, that you've come across in your testing or testing that you've reviewed that tells you that this defendant lacks the intellectual ability to form the capacity to, I guess, have the intent to murder after deliberation and considerable planning.
True.
Is that right?
True.
May I have a moment, Your Honor?
You may.
Nothing further, Your Honor. Thank you.
All right, Mr. King, do you have any redirect?
I do. Thank you. Doctor, Mr. Brockler asked you some questions at the beginning about how you approached your examination and the things that you included in your report and the things that you didn't include in your report and the statements that Mr. Holmes made to you. Do any of those things make your test results somehow invalid?
No.
Do they affect your test results at all?
No.
Do they change Mr. Holmes' mental status or ability to think?
No.
You were asked about generating reports, and you were asked about a case, some other case, called People versus Wood, where you didn't write a report because a lawyer asked you not to write a report. Do you remember that?
Yes.
You wanted to add something, and Mr. Brockler said, no, you can't. But Mr. King can ask you about it. So I'm going to ask you about it. What did you want to add about People versus Wood, some other case?
What I wanted to add was, and I could be wrong, but I thought that I generated an initial report in that case, but then I didn't generate a second report because I was asked to go back and conduct a sanity evaluation of Mr. Wood. And I did not produce a report of his sanity because I testified that, in my opinion, he did not meet criteria for insanity in the state of Illinois.
Did you generate a case in this report? A report in this case?
I did.
Did I instruct you not to generate a report in this case?
No.
Did I tell you what to put in your report or what not to put in your report?
No.
Did you just do what you thought you do normally pursuant to your protocol?
I did.
Does the fact that you didn't generate a report in People versus Wood have any effect on this case at all?
I don't think so. I don't see how.
You were asked about interviewing other people, and let me just ask you a general question. As a matter of course, do you want as much information as you can get? Do you ever know what piece of information is going to be important or not, or do you generally willing to look at anything and incorporate that into your opinions?
Yes, I'm willing to look at anything that is relevant to the case.
Mr. Brockler asked you whether you would want to interview other people that knew the defendant in the case and whether or not that was something that you would want to do. And you said yes, right?
I did.
Is that necessary to conduct a valid neuropsychological evaluation?
No.
When you get a referral from a physician who says, I want to find out what this brain tumor has done to my client's ability to cognate, do you need to do interviews with his parents and with people that know him in order to sit down and administer these tests and get a valid result about what his cognition is?
No.
You were asked about letters. You did review some letters to determine his fluency. What's the importance of that? To determine whether he can read and write and speak in a normal way?
I'm assuming I'm not sure what you're assuming.
You pointed out some letters that were written in order to get into undergraduate school.
Oh. Okay. Yes, my interest was in his writing style, his ability to formulate verbal concepts, his ability to construct grammatically complex or at least grammatically accurate sentence structure. That's what I was interested in.
Okay. And did you get the information that you needed from the materials that you reviewed?
Yes.
Is it necessary for you then to review emails that he sent, to review kites that he sent to the folks in the jail, to review all kinds of other information to determine whether all of a sudden he's lost the ability to read and write?
No.
Would there be any value in doing that, practically speaking, in terms of the validity of your neuropsychological test results?
No, not given the fact that I objectively tested his ability for reading and reading comprehension and visual language functions.
And did they determine that he still knew how to read and write and was fluent?
Yes.
Do you think you would have found anything in the jail kites that indicated that he wasn't fluent?
I don't think so. I'm not sure what a jail kite is.
You were asked about video presentations that he gave in graduate school. You didn't review any visual presentations, did you?
I did not.
Does that affect the testing that you did in any way?
No.
Do you need to review visual presentations or videotape of a defendant or any patient in order to do a neuropsychological exam of them?
No.
Does the fact that you didn't review videotape of Mr. Holmes giving a presentation or being interviewed by the police mean that his cognition is any different than what you've testified to today?
No.
You wrote in your report a certain chronology, right?
Yes.
Is that something that you do as a matter of course when you give a clinical interview?
In terms of how I document, if I understand the question, how I document my review of records that I review, I list them in chronologic order. That seems to make sense to me, and it seems to make sense to the reader.
Okay. And did you also at some point put in your report a history of Mr. Holmes? The information that you gained from him about his life and what had happened to him through the course of your clinical interview.
Through my clinical interview, yes.
What's the purpose of doing that?
Well, one of the purposes is to determine his ability to recall information, autobiographical information from his remote past, his childhood, his development, his relationship, his education, his vocational history, etc. That is certainly one of the primary reasons for that. Also, to assess whether he is reporting that he had learning difficulties at an early age, or if he was abused by someone during childhood or adolescence. All those kinds of factors.
So are you trying to find things that might affect your testing?
Yes, exactly.
Is the purpose of the interview or the statements that you write in your report to do some kind of full-blown examination of Mr. Holmes' sanity or compare the validity of the statements that he made to different people?
No.
You were asked about the notebook. You've now reviewed the notebook, right?
I have seen the notebook.
Is there anything in the notebook that would affect in any way the validity of your neuropsychological testing that you administered either in 2013 or 2015?
No.
Completely irrelevant?
Essentially, to me, yes.
And then finally we got to the testing, the actual testing. You were asked about the SIRS, and there was asked about some concern you might have had that Mr. Holmes had heard about the SIRS during a hearing. Is that right?
That's correct.
Is there any indication from the SIRS that that test was invalid in any way?
No.
Did the SIRS indicate virtually 100% that Mr. Holmes was not lying about his psychotic symptoms?
Overruled?
No. I'm sorry. His SIRS profile revealed no evidence whatsoever of psychiatric symptom exaggeration or malingering.
You're saying none, zero.
Correct.
When Dr. Gray administered the SIRS, was there also zero indication of any malingering?
Yes.
Have you reviewed the reports of the psychiatrists who evaluated Mr. Holmes in this case, now at this point?
Yes.
Have each and every single one of them indicated that there's no indication at all that Mr. Holmes is malingering psychotic symptoms?
Yes, each one documented that.
Now, you were asked about the practice effect and this software program that you used to help calculate the practice effect. Is that a fair statement?
Yes.
And you were asked about the fact that there was day 0 to day 82, and then that some 600 days later is when you administered the second test, correct?
Right.
Does the practice effect stop after 82 days?
Of course not.
Does the manual for the test that you gave indicate right in it that the practice effect will continue to be in effect for between 1 and 2 years?
Yes, the manual of the Wexler Adult Intelligence Scale warns the examiner that practice effects should be taken into consideration and that are likely present up until 2 years, particularly for the PRI.
And that was what you were dealing with, right?
Right.
That's what these questions are about, right?
Right.
And your testing was between 1 and 2 years, right?
Right.
Is there any indication that the practice effect just disappeared after 82 days?
No, that's ridiculous. There is no reason to expect that practice effect is going to disappear after 82 days.
Did you use the only program available to calculate the practice effect?
I use the only computerized program that is available to assess practice effect.
Is that the computer program that's produced by the same people that make the test and suggested that you use?
Yes.
May I please have slide 8? Now, you tell me, if we have a full scale IQ of 123, and then within that 1 to 2 year period, the test is given again, the practice effect should mean that his IQ should go up, right?
Yes.
It should be like a 128 the second time he takes the test, right?
That would be the prediction, yes.
The prediction is, based on the practice effect, that he should have a higher score because he's taken the test before.
Exactly.
But in reality, he got a lower score. Is that right?
Yes.
So despite the practice effect, he still had a significant drop.
Exactly.
If we eliminate the practice effect altogether and don't even think about it and just look at the raw numbers, 123, 116, is that still a statistically significant change in a man in his early 20s?
It is.
Can that be explained by anything else that you're aware of?
Not that I am aware of, and not that I have taken into consideration. That is a decline. That is a decline that represents abnormality, significant abnormality in someone in their mid-20s.
Would it be folly to suggest otherwise?
Yes.
Now, you were asked about these two tests that involve timing and resulted in some of this decline in the second set of testing. Is that right?
Yes.
The two tests that compose part of the PRI, right?
That's correct.
And the first one was called the Visual Puzzles Test. Is that right?
Yes.
And before the break, Mr. Brockler asked you, isn't it true that if you don't get all the tests within a certain period, if you go beyond a certain time limit, you get 0 as a score? And is that how the test works? That's what his question was, right?
That was his question.
And your answer was, correct me if I'm wrong, yes, that's how the test works.
That is how the test works, yes.
But is that what happened when Mr. Holmes took the test? Was he beyond those time limits and got a 0 for his score?
Oh, he was...
That's me.
No, Mr. Holmes was not penalized by going beyond time limits, except on one item. All the other items that he failed were due to wrong responses or inaccuracy.
So Mr. Brockler's contention that it was due to him missing the time limits is just wrong, right?
That is, yes, that is inaccurate.
He didn't miss the time limits. He just got the puzzles wrong.
Exactly.
The same puzzles he got right in April of 2013.
That's correct.
Does sitting in jail make you mentally slower such that it would account for that kind of a difference?
Not in my opinion.
Does depression account for that kind of significant drop in IQ?
No, not generally, and certainly, in my opinion, not in this case, because Mr. Holmes reported that he was significantly more depressed when I evaluated him in 2013. When I evaluated him in 2015, he reported minimal depression.
Right. When you in 2013, did you ask him, can you rate your depression on 1 out of 10 or something like that?
Yes.
What did he rate himself?
8 out of 10.
What did he rate himself in January 2015?
I believe on the day of my testing, I believe it was 2 out of 10.
So if being depressed makes you slower, he should have been slower on the first test than the second, right?
Correct.
Now, overruled. He's following up on the last answer.
The other test that was pointed out to you was the block design test. Is that right?
Yes.
Now, in the block design test, you also get a 0 if you go beyond the time limit, right?
That's correct.
Did Mr. Holmes ever go beyond the time limit and get 0s on that?
No.
What the scoring does on this test is it gives you different scores based upon how long it takes you to solve the puzzle, right?
That's correct.
So if you solve it in a certain amount of time, you get a higher score, right? A shorter period of time.
Exactly.
A little bit longer, you get a little lower score, right?
Right.
A little bit longer, you get a lower score, right?
Right.
A little bit longer, you get a lower score, right?
Right.
And then if you pass the deadline, you get a 0, right?
Correct.
Mr. Holmes got no 0s, right?
He did not.
But he did have a significant decline in the speed with which he could solve these puzzles. Is that correct?
He was significantly slower on many of them, yes.
And that's why he scored lower, right?
Yes.
Isn't that the point of the whole test?
It is. It
The
is.
speed?
Right. It is the speed with which you can analyze spatial relationships and construct those same patterns accurately.
Is it not true, Doctor, that one of the chief cognitive effects of schizophrenia is that it slows down the speed, the ability of people to think quickly. Isn't that one of the most profound cognitive effects of schizophrenia?
Sustained.
Is that, or is that not, one of the cardinal, most profound effects of schizophrenia on cognition?
Neuropsychologically, speed of information processing is one of the most consistently found cognitive deficits in schizophrenia spectrum disorders, not just schizophrenia.
So the fact that he got a lower score because he was slower indicates, is that significant in any way? Is that some kind of mistake in the test? Is that an erroneous score?
I don't believe so. I believe it's a reflection of pathology.
And that pathology is psychopathology, right?
Correct.
Did anything that Mr. Brockler just said to you this afternoon, anything, affect in any way the validity of the neuropsychological testing that you did?
No.
Is anything that Mr. Brockler said this afternoon affect in any way Mr. Holmes' cognition and the fact that he's had a dramatic drop in IQ over the past 2 years?
No.
I just asked you a question about psychopathology. That means the underlying psychiatric illness, right?
Yes.
I have no more questions, Your Honor. Thank you.
Do you have any recross, Mr. Brockler?
So, Doctor, I'm interested in clarifying some of the things that you got out here with Mr. King that you agreed to. When you were talking about the practice effect and you relied, it looks like exclusively on that software for coming up with the number that you reported in your report to us. Is that fair for the practice effect?
I did rely on the software as I reported as I put in the report.
And in between the yells and stuff, what I lost was that number based on a presumption that it was no more than 82 days after that guy took the test again. Is that fair? That's what the software says, right?
That's what the software says, yes.
So when you suggest, hey, jury, it doesn't matter, there was still a practice effect to be intended, it's not the same practice effect that you just testified to at 128, is it?
Well, it may not be. However, in my field, we know from multiple empirical studies that practice effects on the Wechsler Adult Intelligence Scale exist for much, much longer than 82 days, which is then why many neuropsychologists throughout the country use that same program that I use with intervals much longer than 82 days. In fact, the authors and the publishers provide case examples that are up to a year or longer in the book that they publish that goes with the WAIS-4.
Thank you, Doctor. You're not telling us that the defendant's practice effect some 600 days later would be as accurate as it would be at 82 days later. You're not telling us that, right?
It probably would not be.
So what you're telling us is you used an inaccurate tool in your report, fair? It was either accurate or it wasn't, Doctor.
I don't believe it was inaccurate. I think it is an applicable tool to use. The cutoff is different, but given what we know from the research in practice effects, it is the practice effects go much longer. The other thing is you can completely eliminate practice effects completely, and you still have a significant change.
Did you understand my question?
I believe so.
My question was, you used an inaccurate tool in your report, fair?
I don't believe so.
Do you believe that the practice effect would have revealed a IQ score, a full-scale IQ score of 128 600 days later, just as it did 82 days later, unchanged?
In a normal person without any psychopathology or any neuropathology, that is certainly possible.
That's not what I asked you, Doctor. Look, you testified. There's a hand formula you could use, right?
There is.
And if practice effect, as you've testified to previously, is based on the length of time for in between tests, doesn't just common sense indicate that 82 days later is going to be different than 600 days later?
Well, and I understand that line of reasoning. However, there are other factors to take into consideration, because with people with much higher level of intelligence, practice effects endure for a much longer period of time.
I just want you to tell us, Doctor, that you think that his performance on that WACE 4 would be the same 600 days later that it would be 82 days later. Just tell us that.
Object to the form of the question is argumentative.
Overruled.
Go ahead.
I don't know that it would be exactly the same, but it would be increased.
Are there any other tools that you use that were software driven and limited in the way that we've described here?
I'm not sure I understand the question.
Oh,
For scoring, you mean?
Yeah, that's right. I mean, are there any other software things that we should be aware of where it cuts off at a certain level and it doesn't factor in certain things, or what? I mean, anything else you relied upon other than your own work that would have given us an answer that is less than accurate like this one?
No.
I'm confused about something that you said, and that is you told Mr. King it wasn't important for you to be able to talk to the defendant's parents or other people that were close to him to do the job you were told to do. Do you remember that?
Yes.
I swear, I thought you said on cross, you asked him to let you talk to them so that you could factor it into your analysis because you thought it was important. Did you change your mind, or did I mishear you?
I did ask him, but the question that he asked me is not speaking to them. Did that affect the validity of my test results? I believe that was the exchange.
Yeah. Oh, I don't know, Doctor, was it?
That's my recollection.
Do you remember testifying in a case called Missouri versus Driscoll? Bless you. Do you remember that?
I remember the case.
Yeah, it's a death penalty case from Missouri. Do you remember that?
Yes, it's a horrific case.
Yep, and you were asked to conduct a neuropsychological evaluation, correct?
Yes.
And one of the things that took place during your testimony was an exchange where you were asked about things you did beyond reviewing the records you were provided by the public defender's office. Do you remember that?
Yes.
And your answers were this, and you tell me if you agree with this. Well, I talked to Gloria, Mr. Driscoll's mother, and Amanda, a friend, and then I also talked to two of his cousins. Do you remember saying that? Words to that effect?
I don't remember the cousins, but I remember the other two.
If you'd like to see the transcript, I have a copy of it for you.
It's okay.
Question: why do you review records and talk to witnesses in performing a neuropsychological evaluation? Answer: to try to obtain as much information from as many sources as possible. Do you recall saying that?
That sounds like me.
You also go on to say it's also important to get input from individuals, significant others who know the defendant very well. Do you recall that?
I believe I said that.
Follow-up question. And that provides you, like when you talk to witnesses, that would provide you with insight into that person's behavior at times other than when you actually evaluate them. Answer from you, true. Fair?
Yes.
That did not happen here, correct?
Correct.
Because you weren't permitted to do it, correct?
True.
You were asked, too, about the questions that we went into and about whether or not they had an impact. Doctor, you don't just ask questions for fun, do you?
I do not.
You ask questions with a purpose in mind, correct?
Yes.
And Mr. King said you ask questions to find out if there's something that's going to impact the testing that you're about to do, correct? Well, why do you
I guess he did. I
well,
don't recall that specifically, but I believe you.
I'll go big and broad. Sorry to interrupt you. Why do you ask the questions you ask?
to obtain information that is, that I think is relevant to my understanding of development, education, and how they may impact neuropsychological status.
Okay, why did you ask questions about the defendant's drug and alcohol use?
To determine if he had a history of drug and alcohol abuse that might affect his cognitive status.
And he told you of none, right?
I believe so.
You need to look at your report.
I think he said he might have smoked marijuana a couple times.
But that's not something that's going to, in the past too, way in the past, right?
Right.
That's not something that's going to impact your testing here, right?
No.
In fact, he even told you that he smoked the occasional cigar once a month in the past.
I believe he did. I believe he did.
Not going to impact the testing, correct?
I don't think so.
One of the things that you did not echo back to Mr. King was when he asked you if the defendant was lying about his psychiatric symptoms based on his performance on these validity scales and these other tests. Do you remember that?
Judge, objection, may we approach?
Yes.
May I inquire, Judge? I'm sorry.
Yes, you
Sorry.
may proceed based on the discussion that we had at the bench.
Yes, sir.
The objection is sustained.
Yes, sir. One of the other things that you were asked by Mr. King was whether or not any of the emails, texts, other writings closer to the time of the crime were relevant to your consideration in this neuropsychological set of evaluations. Do you recall that?
Yes.
And you had said they were not. Do you remember that?
Yes.
And so that we're clear, what was important were the two things he generated back in 2006, 6 years prior to this crime. That's what you were saying.
Those two things were important.
And not the things in between, correct?
Not the emails and the text.
Nor any of his papers that he wrote to his graduate professors, correct?
I would have preferred to have read those, some of those documents, but I don't believe I'd had access to them.
Weren't given them.
I don't believe so.
And then you talked about the notebook too, and how that seemed to have zero impact on your neuropsychological assessment. Fair?
Yes.
One of the things, though, that's contained in that notebook is a series of pages that lay out in pretty good detail planning for the murder of people in the Century 16 Theater. You'd agree with that, correct?
Yes.
I mean, I don't know if you could call that the like a Wisconsin card sorting test, but there's a lot of problems identified in that notebook, fair?
Yes.
And ways to work around those problems, yes?
Yes.
He considers the pros and the cons of not only whether to attack an airport or to conduct serial killing, but also which theater within Century 16 is the best to maximize casualties, correct?
I believe so.
These all feel a lot like what you've described as executive functions, don't they?
They certainly...
To the characterization of the question is feel like.
Overruled?
Go ahead, Doctor.
They are certainly reflecting strategic planning.
Have a moment, Your Honor.
You can. All right. The jury appears to have some questions for you, Dr. Hanlon, so I'm going to ask you to please give us a moment, okay?
Certainly.
All right. Thank you. Members of the jury, this is probably going to take a few minutes, maybe 5 minutes. Would you prefer to stay in the courtroom and have me turn on the static noise, or would you rather go out? You're okay with me doing that? Okay, feel free to talk to each other, just not about the case, okay? All right. Okay, would counsel please approach? All right, Doctor, the jury has submitted some questions that, based on the rules of evidence and other applicable rules of law, I have found are appropriate. The first question reads as follows. Why, if you stated that talking to families of the patient is so important for clinical interview, would you not stand by your belief and tell the defense that it was something you needed to do?
Well, I do think that interviewing what are often referred to as collaterals, family members, friends, etc., I do think there is important information to be gained from that. I requested to be able to contact family members and interview them. I was told that...
You can't get into hearsay, so...
Okay.
Which would be what somebody said to you.
Okay. As a result of being told that I would not be allowed to do that, I chose to proceed and conduct the evaluation that I had agreed to do, despite the fact that I was not able to interview family members. It was not optimal, it was not ideal for me, but I capitulated to that situation.
The next question is, you stated that much of the information and reports available regarding Mr. Holmes was not relevant to performing an accurate neuropsychological test. Why review any data rather than only the data provided by the defense?
If I understand the question, I think it's a good question. I reviewed, I was provided with a massive amount of data, and I chose to review data that I thought was relevant to the questions that were being asked of me. I often conduct clinical neuropsychological evaluations of patients with various types of brain disorders with minimal information, and that is just the nature of that kind of situation. There often just is very little information, very little history available, particularly on inpatients. Again, I proceeded with the evaluation. I'm not sure I'm answering the question at this point, but I conducted the evaluation to the best of my ability and tried to do an objective determination of his neuropsychological status, incorporating the information that was made available to me that I thought was relevant.
The next question is, are any sections of the neuropsychological test graded on a subjective basis? If so, what sections, and how do you subjectively grade those sections?
No, good question. No, neuropsychological testing is, there is no subjective scoring or subjective analysis of scores. The scores are what they are. The scores are objective, meaning that the examinee performed, responded in a certain way. They answered a question with certain words, they responded motorically, they responded after some visual analysis, and they make a choice. Then those choices then generate a raw score. That raw score then is converted into what's called a scaled score or a standard score, which is based on a normative sample of people that are typically from the same age group, often from the same gender, and in many cases from the same educational level. So that is the objectivity. There really isn't a subjective element to the scoring. There is some subjectivity that comes to interpretation of the objective scores.
The next question is, would slowing down a bit purposefully on the block design or visual puzzles test be a sort of malingering which could affect results if a person understood how the tests worked?
Again, insightful question. There is a remote possibility of that. However, that would then require, if there is no evidence of that similar kind of slowing down on any of the other speeded tests that were done, and there were a multitude of other speeded tests that were given, and he didn't slow down on any of them. In fact, he got faster on many of them. So that kind of selectivity in terms of I'm going to slow down on this, but I'm not going to slow down on this, I'm actually going to go faster on this, it doesn't, it's not consistent with, it's not suggestive of intentional misrepresentation.
The next question is, if you know, and if you can answer this question in other words, can lack of intellectual stimulation as incarceration in isolation cause a nonverbal decrease in scores?
Lack of intellectual stimulation. Lack of intellectual stimulation. My understanding of, and there is a body of research on this topic. It's not a very broad or deep body of research, but it exists. The effect of isolation is more likely to cause emotional changes than it is to cause intellectual changes, particularly on people who are already vulnerable or predisposed to have some mental disturbance. I suppose there's the remote possibility that you could, if you then become depressed due to social isolation, that could then have a secondary effect on intellectual functioning, but it would primarily be the effect on emotion, mood.
The next question, again, if you know, can going from actual hands-on experiments to only reading cause a decline in nonverbal scores?
Okay, so if I understand the question, I'm just going to infer what I understand this to be, going from doing hands-on experiments in a research lab in a neuroscience program to spending one's time in a jail cell reading. That's my interpretation of the question. And I'm sorry, and then what was the final point of it?
The question is, can going from actual hands-on experiments to only reading cause a decline in nonverbal scores?
I do not believe so.
And the last question is also, going from playing many video games to none cause a decline in spatial scores? S-P-A-T-I-A-L.
Huh, good question. I don't believe, in my opinion, no, based on the difference between video game engagement and the kind of test structure that is involved in intelligence testing. I don't think so. I think it would be more likely to affect attention.
Any follow-up questions based on those questions, Mr. King?
Yes, Your Honor.
All right.
The first question you were asked, I think, was about talking to family. And I think the question was, if you thought it was so important, why didn't you refuse to do the evaluation? If you thought that it was so important to talk to Mr. Holmes' family, that it would invalidate your neuropsychological testing in any way, would you have conducted the testing or would you have refused to do it?
If I thought there was any remote possibility that me not having the opportunity to speak to family members would somehow, and I don't know how that could possibly happen, invalidate test performance in a neuropsychological evaluation, then yes, I would have refused to do it.
Was that the case here?
That was not the case here.
Have you subsequently reviewed reports from Drs. Gurr, Metzner, and Reed, psychiatrists who all did interview Mr. Holmes' parents?
Yes.
Was there anything contained in those interviews which would have affected your neuropsychological testing or results in any way?
No.
You were asked, why did you not review any data other than was provided to you by the defense, I believe. Did all of the data you received come from the defense? Did Mr. Brockler provide you with any information?
Not that I'm aware of.
Did the court provide you with any information?
No.
Did you go out and conduct your own investigation?
No.
Did all of the information you received come from me in my office?
Yes.
Did we provide you, you said a massive amount of information. Did we provide you with such a massive amount of information that it would have taken many, many months to even read all of it?
Yes.
Do you at some point have to make a decision about whether or not there's any value in reading every possible piece of information or finding out every possible fact about the case before you can conduct neuropsychological testing? Does there have to be some prioritization going on there?
Yes.
Now, you said that in some circumstances you conduct neuropsychological testing with virtually no background information. Is that right?
Yes, that is relatively common with clinical patients.
And does that invalidate the test or the results of the test in any way?
Not at all.
We asked about subjective grading of these tests. Do you have any ability to subjectively change or manipulate the scores on the test, or is the test a true objective measure?
The tests are true objective measures, and the scores are not subjectively changed in any way.
I asked about if someone were to deliberately slow down on one of the tests, could that affect it? And I think you said there was a remote possibility. Do you see any indication based upon Mr. Holmes' performance on the test and based upon all of the validity profiles that were conducted by you and Dr. Manguso, that he did anything but offer an optimal, put his best effort into all of these tests?
Yes, in answer to, I interpreted that as kind of a hypothetical question. Maybe I shouldn't have. But there is no question in my mind that given the multitude of measures, tests, to assess his effort, to assess the validity of his responsivity, there is no question whatsoever that the tests I did are valid and accurate. I also believe the tests that Dr. Manguso did are valid and accurate.
You were asked about whether the lack of intellectual stimulation from being in jail, for example, could result in someone having a decline in IQ. And I believe you said that the answer was no. Is that right?
I do not believe that is going to directly change IQ.
So being isolated doesn't make your brain work worse, does it?
No, it's not going to change intellectual functioning.
Well, you did say it might affect someone's emotions in terms of being depressed, and being depressed may have somewhat of a possible effect. Is that fair to say?
Right.
If that was the case, would his scores have increased then because he was less depressed, significantly less depressed during the second testing than the first testing?
Right.
Objection. Overruled.
You were asked if moving from doing experiments to just reading would result in a decline in IQ. Anything about doing experiments to reading that would make you unable to reduce your IQ?
No, I think I said no.
Okay. And playing video games, is that the same?
Correct.
Thank you. I don't have any other questions.
Mr. Bruckler, do you have any follow-up questions?
I do, Your Honor. Thank you. A couple things. First off, I just want to clarify the information that you were provided is limited by who hired you, correct?
Yes.
And so what they choose to give you or choose not to give you limits the things that you're allowed to consider. Fair?
True.
And that includes access to the parents, right?
Yes.
And what I don't want to do is walk out of here with the idea that I'd love to talk to the parents, but it's no big deal if I don't, because that's not what you said in a death penalty case in Missouri, is it?
It's not.
It's important, right?
It is preferred.
And important.
And it can be important. I've certainly talked to family members that turned out to not be very important, but it is preferable to have the opportunity.
And you can't know till you do it, right?
True.
So what Mr. King then asked you is, well, hey, didn't you well after the fact get an opportunity to review reports by psychiatrists who may have reached out to the parents? Do you recall that?
Yes.
They're not neuropsychologists, are they?
No, they're not.
And they talked to them well after you had the opportunity to do your first set of testing on the defendant, right?
Yes.
A couple other things. Look, this question about can you malinger on the block test, it's interesting, isn't it? It's an interesting question. You'd agree with that?
It's an interesting question.
If somebody knew that they could still get all of the puzzles right, block designs right, but if they just counted to 30 in their head the second time around before they answered, they could change their score on that test, couldn't they?
I suppose if someone was that experienced with the test and knew what the time parameters were, I guess an experienced neuropsychologist could do that.
Well, they don't have to know the time hacks. They could just say, hey, I'm just going to take longer to answer the questions, right?
They could, but then at times they would be going beyond the cutoff, because there are some 30-second cutoffs.
So if it was someone smart, let's say, who knew about stuff like the test, right?
Again, if they knew what the administration structure was of the test, they could probably do that.
And frankly, if they hypothetically had taken the test, 20 months earlier, and that information had been provided to someone that they had access to, that might give them that kind of information, wouldn't it?
Then that would be a significant practice effect.
Yep. And in the opposite direction, right?
Right.
The other thing I wanted to ask you about was this idea that, do you remember on redirect or direct, I can't remember, Mr. King said, hey, do you see how this guy's verbal scores are going up? Couldn't that be attributable to the fact that he just reads all day in jail? Do you remember that?
Yes, vaguely.
Well, did you testify that reading all day in jail could increase his verbal scores on some of the neuropsychological testing you did?
I believe I did.
And I just want to make sure I got this right. If he focuses his time and attention on the task of reading, your opinion is it could increase his verbal score. But if he loses out on all of the other mental stimulation that he had had prior to committing this crime, that it would have no impact, up or down, on his brain. Is that fair?
Objection to increase his verbal score. There was no increase.
Overruled.
Go ahead. You've already testified to that, Doctor, but did you understand my question?
I think I did. Well, I think what you're getting at, and I am too technical about it, but we're talking about the difference between what's called crystallized intelligence and fluid intelligence. Crystallized intelligence is knowledge-based. It's what we acquire from reading, study, etc., verbal-based. That's called crystallized. Fluid intelligence involves constructional abilities and perceptual functions. In my opinion, not engaging in constructional tasks is not going to have a major impact on performance on something like block design because it's a novel task.
Doctor, you talked about the normative factors on some of these tests to include age, gender in some cases, ethnicity in some cases, education in some cases. You agree with all that?
Yes.
These are attempts by these test makers who you follow the rules and get the answers and plug them in and the computer tells you what the answer is, correct?
In some tests.
Yeah, and these are the things that they tried to make normative so that they take into consideration these factors. Fair?
Yes.
Is there any test that you administered that allows you to take into consideration whether somebody is free and, let's say, in their first year of neuroscience versus 900 days later after having been in isolation, 2 weeks from starting a death penalty trial? Is there any normative way to compare those two?
No.
So the test presupposes that the defendant, having taken this test back in, let's say, January of 2012, they score that the same way as January of 2015. Correct?
They're scored the same.
Nothing further, Your Honor.
All right, may Dr. Hamlin be released from his subpoena? Is there any objection? Is there any objection to that?
No, sir.
All right, Doctor, thank you.
Okay, thank you, sir.
All right, members of the jury, it's 7 minutes till 5, so we're going to go ahead and stop for the day. Since we're about to start a long weekend, you know what's coming, right? That's right. I'm sorry I have to do this, but these are extremely important. You know that already. And I know you know these by heart, but I sleep better at night when I give them to you. So I need to give them to you. I'm hoping that we will have the case to you for deliberations at some point during the week of July 13. So we're making progress. But it is important that you continue to abide by all my admonishments. They are all extremely important, and I ask that you not take the attitude of who cares if we violate one time, or the attitude of nobody's going to find out. Please avoid taking either attitude. That would be problematic. We rely on you. We took our time selecting a jury, and we selected you because we are confident that you can handle this and you can do this. I know these are difficult things that I'm asking of you, but I have all the confidence in the world that you can do this. And I want to go through all the admonishments again. Number one, please do not discuss any aspect of the case with each other through any means. You're free to talk to one another, and I encourage you to be friendly with each other, but you cannot talk about the case or anything related to the proceedings or any part of your service as a juror in this case. Number two, in addition to not being able to discuss the case with each other, you may not communicate about the case with anyone else through any means. And you may not communicate about any other case like this one with anyone else through any means. That includes your spouse or significant other. All you can tell people is that you're a juror in a trial in Arapahoe County that is expected to end in August of this year. Number three, you may not have any contact or communications with any jurors who have been dismissed. And that includes in person, by telephone, by text. electronic means, through any means. Number 4, please do not talk to any witnesses, parties, or attorneys about anything, whether related to the case or not. Number 5, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse premises and that it is visible to everyone around you. Your juror badge will also reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location. And in the event that despite your best efforts, you hear something about the case from anyone, regardless of what role that person has, if any, in the case, or whether they're just a member of the public, whoever that person is, please let my staff know that you need to talk to me. All you have to tell my staff is you need to talk to me. Don't go into any details about what it's about, what it is that you need to talk to me about, and I will bring you in here and I will talk to you in private. Number 6, please do not talk to any members of the media about anything. Number 7, you must not read, view, or listen to any news or media reports that may refer to the case. Because there is media coverage of the trial, I ask that you be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. I think the best thing to do is to try to avoid news reports or try to avoid listening to the radio or watching the news at times that you know news reports are going to come on. I think that's just the safest way to go. There are going to be times when there are media reports about things that you've seen here in the courtroom, but there are also going to be times when there may be media reports about things that the lawyers and I are talking about outside your presence. The reason we're talking about those things outside your presence is because you're not allowed to hear about them. That's by law. And you should not speculate about those things. You should not infer anything from those things. And you also should not acquire any information about any of those proceedings. But you're also not allowed to receive media information about the case, even if it's about proceedings that you may have been present for. You just cannot receive any information about the case from any media source. Number 8, you cannot visit any locations that are mentioned in the case or conduct your own investigation outside the courtroom. That includes looking terms up. That includes using references from outside the courtroom, including encyclopedias or legal books or treatises of a scientific nature or religious books. You just cannot refer to any source outside the courtroom, any outside source. We want to make sure that you make all decisions in this case based only on the evidence presented in the courtroom and the instructions of law that I give you, which is my next admonishment, and that is your verdicts in the trial must be based solely on the evidence presented in the courtroom and the instructions of law that I give you. I've said this in different ways in the past, and I mean the same thing. All your decisions in this trial have to be based on the evidence presented in the courtroom and the instructions of law that I give you. Number 10, you cannot start forming any opinions about the case until I tell you that you can start deliberating. You must keep an open mind throughout the trial. Sometimes in our culture, we get used to thinking about things in terms of which side is ahead or which side is behind, or, oh, this side just went ahead or went behind. You have to avoid the temptation to think along those lines. You have to keep an open mind throughout the trial, and you have to be mindful that the defendant in a criminal case is presumed innocent, and that presumption of innocence stays with him and must be given effect by the jury throughout the trial. Number 11, neither sympathy for nor prejudice against the prosecution or the defendant may affect any of your decisions in this case. And number 12, and finally, remember that the attorneys have a job to do. They are required to make objections. Please don't hold it against them when they make objections, or if they ask for a bench conference. They are doing their job. That's what they're supposed to do. Similarly, please don't read anything into my rulings in terms of me being for one side or the other. You should not even keep track of how many objections I'm sustaining for one side versus the other, or overruling against one side versus the other. I'm neutral in these proceedings, and I'm simply doing my best to apply the rules of law, including the applicable rules of evidence. So that's all I'm doing, and that's all you should infer from my rulings. Does everybody understand all those admonishments? Yes, and I know you know them by heart, and I know you're smiling at me like, yes, you've given it to us a bunch of times, we get it. Please have a great 4th of July weekend, get some rest, and then I'll see you back here at the usual time on Monday morning. Actually, not at the usual time, I know. I was just testing you. 9 o'clock Monday morning. You should be here about 8:45. Thank you. All right. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. In terms of scheduling, Mr. King, I know that you've fallen behind of what you anticipated in terms of how many witnesses you were going to be able to call today. When are you thinking now you might be resting?
Well, I think now we're bleeding into Thursday of next week.
Okay. All right.
I don't know that for sure, but based upon the way it went today, I think that's probably more accurate.
Okay. And some of it depends on how long Dr. Gurr takes as well. And given that the estimates have been off on the by being too short, it might be that we go into most of Thursday. I mean, if the estimate with respect to Dr. Gurr ends up being short as well, as it has been with respect to other experts, then we might go into most of Thursday, which means that the prosecution may be calling their rebuttal witness on Friday possibly instead of Thursday. So
Yeah, at this point, Your Honor, we just don't know how long any rebuttal case we would have. I don't anticipate it going longer than next week, but again, these things are all fluid.
I understand. And we may not be able to do closing arguments on the 13th. It may be the 14th, and that's fine. Or we may be able to keep the 13th. So, but, you know, some issues have come up. There will be some other issues that are going to come up. It's just part of the process, and we'll deal with them the best we can, and we're making the best estimates that we can and trying to predict the best we can about how long things are going to take, but that's always a difficult proposition, as everyone knows. So my goal is still to see if we can finish with the defense's case by Wednesday, to see if the prosecution can present its rebuttal case on Thursday, and perhaps into Friday, and to be able to do closing arguments on Monday. That's still my goal, but it may be Tuesday before we get to closings.
And Your Honor, assuming that we get done next week with what we need to do in order for closings to take place Monday, just so that we can inform people in case they ask, was Your Honor planning on them closing starting in the morning, first thing, sometime later in the afternoon, just so we know?
9 o'clock, unless, again, something changes. For example, if your rebuttal case takes until the end of the day on Friday, then I'm probably going to need some time on Monday to talk to you about instructions, and that may mean that we have to wait until Tuesday for closings. Or it's possible that we have an instructions conference on Friday afternoon because we have a little time to do it, and we just need an hour on Monday morning to finalize things, and then we can start at 9 or 10 or something like that. So my goal, again, is to start closings at 9 on Monday, but everyone has to be flexible. If we start at 9, my plan is to give the jury the instructions and sample verdict forms, read those, go through those and read them. That's going to take about a half hour, maybe 40, 45 minutes. Maybe take a break at that point, start with the prosecution's closing argument, have the prosecution make its closing argument in the morning, take a lunch break, have lunch brought in for the jurors to save some time, and then do the defense's closing in the afternoon and the prosecution's rebuttal close after that with a break in between the two. So we would probably have to take multiple breaks throughout, just given that each side is going to have 2 hours for closing arguments. That's the plan. But it depends on how much we get done next week, obviously.
Thank you for that information, Your Honor.
Okay. In terms of the instructions, the draft instructions, my staff will distribute those to you. This is the latest draft. And two things that I want to point out about this draft, and we'll have arguments later, so I'm not looking for argument right now, but I'm just giving you a heads up. Number one, I've included lesser included offenses, the 2 lesser included offenses for each charged crime that Ms. Nelson asked for, except for the possession or control of an incendiary device, an explosive or incendiary device. That one doesn't have, there are no requested lesser included offenses, but I was persuaded by what she said, and so I've included those. And the other thing is that, as you know, the verdict forms have different parts. Part A asks the jury to decide guilty or not guilty, and if guilty, then to choose whether guilty of the charged offense or one of the lesser included offenses. Part B would ask the question about insanity, and essentially it would be, if you found the defendant not guilty, did you find them not guilty solely because of the insanity defense? The way the instructions in the verdict forms read right now, the jury would not get to that part B of any verdict form unless they first find the defendant not guilty of all 165 charges and all of the lesser included offenses. And that's different than the draft that I gave you earlier, and that draft was wrong. There's a statute on point in Colorado. There's a Colorado Court of Appeals case, and there's a Colorado Supreme Court case. So, and the reason is you want to avoid a situation where the jury might find someone guilty of a count and not guilty by reason of insanity of another count. And in that case, one count would dictate that he be sentenced, for example, to prison, and the other one would dictate that he be sentenced to the mental health hospital. And so in order for the jury to answer the question about insanity, the jury first has to find that the defendant is not guilty of all the counts and all the lesser included offenses. So take a look at the instructions, take a look at the verdict forms. By the way, this is consistent with the model instruction, and if you remember, I had deviated from it when in the first draft, and I think I asked Mr. Orman about it at that time, and he said, yes, Your Honor, I think it's right the way you've done it. And he kept bothering me about why the model instruction would be wrong. And the model instruction is not wrong. The model instruction is right. And again, there's a statute that's right on point that says this is exactly how we do it. And there is a case from the Colorado Court of Appeals and a case from the Colorado Supreme Court. I'll take argument later when we have the next conference, but
I hate to ask the court of something the court would normally ask me, and just so I can go look it up, do you happen to remember what the citation is of that statute?
I remember the case is Bilecki, B-I-E-L-I-C-K-I. Actually, I have it on my desk. Ms. Garland, can you get it? It's on a piece of paper on my desk, and it's got my handwriting, and it's in blue marker. Thank you. I'll give you the statute, and I'll give you the cases as well. Hold on just a second. And let me clarify, this does not change the burden of proof. The burden of proof applies with respect to each count, including the sanity element. This is simply related to the verdict forms. And what the case law says is that if the jury finds the defendant guilty of even one count or a lesser included offense, We don't care what the reason is for the finding of not guilty on any other count. And that's why the jury in that situation doesn't even get to the question about insanity. All we care about at that point is that they have found him not guilty of those counts. Again, because we don't want a situation where you have one guilty verdict where the court has to sentence him, for example, to prison, and another one, a not guilty by reason of insanity verdict, where the court has to send him to the Department of Human Services, commit him to the Department of Human Services. The case is People versus Bielecki, Bieleki. It's cited at 964 Pacific 2nd at 598. That's a Colorado Court of Appeals case from 1998. And then People versus Collins, 752 Pacific 2nd, 93. That's a Colorado Supreme Court case from 1998. And the statute is section 16-8-105.5, subsection 3. Okay. Is there anything else at this time before we adjourn? Anything on behalf of the people?
Your Honor had indicated that you would be willing to email us copies of...
Yes, my staff will do that right after we end today. Anything on behalf of the defense?
Your Honor, may I approach with a member of the prosecution, please?
Yes. By the way, before I forget, and we'll get to you, Ms. Nelson, in just a moment, P-TR-1258, I said I would defer ruling on it, and this was from the profile from the Northwestern website. Does anybody have that? Are you still seeking its admission, Mr. Bruckler? It sounded like you got what you needed from it.
I think that's right, Your Honor. I mean, I'd always like a visual reminder of it, but I think I got out what I needed to.
Okay, given that, I'm going to deny the request to admit. So if you want to mark it as a trial court exhibit, you can, but I think it would be cumulative at this point. I'll give it back to you. I didn't want to forget to do that. Thank you. All right. Ms. Nelson.
Sorry, this is a bit awkward, Your Honor. As I began to explain at the bench, and I'll just repeat what I said.
Actually, hold on just a second. Can we take a 5-minute break? Yeah. Let me take a 5-minute break and come back and take it up, okay? Thank you. All right, we'll take a 5-minute break and then we'll start again. Sorry. The court will be in recess for 5 minutes. Thank you.
Please rise.